Hello students, TYBBA Legal Aspect of Finance and Security Law. I am Assistant Professor Shreeraj Bhor. Let's go through with important questions of Companies Act 2013. In this chapter, Companies Act 2013 features of company and Articles of Association and Memorandum of Association. These two chapters are most important. Background of Companies Act 2013. Economic reforms 1991, then growth of Indian economy. Financial instruments were introduced. Indian companies also started expanding globally. Indian companies also started expanding globally to accept the new challenges and tap the new market. The old Act 1956 was outdated. The Lok Sabha passed Companies Bill 2012 on 18th December 2012 and the Rajya Sabha passed this bill on 8th August 2013, thereby replaced the old Act Companies Act 1956 to the new Act Companies Act 2013. It was structural reformation in 1991. Liberalization, privatization, and globalization policies were accepted by India. Indian companies were become multinational companies, and because of that, the new act is most important and required. Definition: the company means the company incorporated under the act and any previous company law. So all registered companies under the Companies Act 2013 are called as companies. Then company is an incorporated association which is an artificial person created by law having a separate entity and the perpetual succession and common seal. All the features of companies are included in this definition. The joint stock company means a company having a permanent paid up capital of nominal share capital of the fixed amount divided into shares, also fixed amount of held and transferable as stock and dividend, and held partly in one way and partly in other way, form on the principle of having for its members the holders of these shares or their stock or other persons. This is definition of joint stock company. Features of company: first is incorporated association. It is registered with company, that's what it's called as incorporated association. Separate legal entity: companies are having separate legal entity other than the owners and management of company. Artificial person, and it is not a citizen of India, so they are created out of, they are generated as an artificial person and law provide different liabilities to them. Limited liabilities: all the companies are having limited liability of the shareholders up to the face value of shares. Perpetual succession: so they are irrespective of life of owners, all the companies will be there for generation by generation. Transferability of shares can be easily transferred from one person to another. Sale is one transfer and nomination is second transmission of shares. Common seal as a substitute of signature, as act provides separate legal existence to the company, so sign provide authority to company as a signature. Separation of ownership and management, so ownership is in hand of the shareholders of the company and management is in the hand of board of directors of the company. Next is statutory obligations. Statutory obligations means Some rules and regulations are there for companies, and all the companies are required to fulfill all that rules and regulations. That is called as statutory regulations. Means all the companies are required to follow Companies Act 2013. Finding This is next part, stages of promotion. First is finding an idea, then investigation of practicability of idea, whether it is possible to implement that idea in practicality. Then preparation, this is related with planning and financial, who is going to fulfill the financial requirement, whether bank is ready to provide loan or not. So this is third part. Next is approval of name of the company. So all the promoters are going to apply for 6 names to the government, and government is going to sanction one name out of that 6. Next is related with directors taking over the charge. So promoters become directors of the company, and they start doing business as a board of directors. So all these points are required in the stages of promotion stage. Incorporation stage, the mode of forming incorporation, company section 3. The company may be formed for any lawful purpose by 7 or more person in case of public company, or any 2 or more persons in case of private company. So public company required minimum 7 members, private company required minimum 2 members. In case of one person company, it is to say the private company by subscribing their names to the memorandum of association, and otherwise compiling with the other requirement of the act in respect of registration form in the incorporation of the company.